Rob Wells here with you from the Law Office of Robert M. Wells. Our office specializes in helping out landlords dealing with their landlord-tenant problems. And in this video, I'm going to further explain what I think AB-2179 means for landlords and property managers and what effects it will have for you during its application. Before I go into that, though, landlords, property managers, if you're facing a situation where your tenant hasn't paid you rent and you're considering terminating a tenancy or need any help dealing with that non-payment of rent situation, please feel free to reach out to us below. Now let's begin. So, as everyone probably knows, or you may have heard, AB 2179 passed last week. It is now in effect. The summary of what AB 2179 does is it precludes certain types of non-payment of rent evictions from April 1st, 2022 through June 30th, 2022, particularly for those landlords and tenants who have applied for rental assistance from the state of California or your local sponsored program if your county or city decided to go that route. In a nutshell, and we have to kind of step back a couple of steps about the COVID restrictions enacted in 2020 and so forth. So what the state of California has done and protected tenants from eviction from non-payment of rent for the 2 years we've been dealing with COVID, there were basically three classes of COVID rental debt. There was COVID protected period debt, which ran from March 1st of 2020 through August 31st of 2020. Then this debt called transitional period debt, which was from September 1st, 2020 through September 30th, 2021. And then finally, debt, which was called COVID recovery debt. And that period was from October 1st, 2021 through last month, March 31st, 2022. In a nutshell, what the state of California made landlords do before they went to court was, hey, you have to apply for state rental assistance and either, get denied rental assistance, or the state had 20 days to act on your application, or your tenant had to give you notification within 20 days that they have completed a rental assistance application. And if you didn't receive any communications from your tenant or the rental assistance program, you could move forward and go file an eviction case or go file a case in small claims court or whatever, take a civil action to sue your tenant, basically. The legislature knew that the state rental assistance program could not act within those 20 days, and there were a whole glut of backlogs of processing rental assistance applications. You all might have experienced that. I think pretty much, I have so many stories of landlords waiting, 60, 90 days for rental applications to be approved, and, they got shuffled all over the place. So realizing that the state extended eviction protections for those that applied for rental assistance, so that the state had enough time to review the applications, get the checks to where they needed to get paid, and so forth. So landlords, property managers, if you had tenants that actually completed their application before March 31st, before the state cut off all the applications, certain eviction protections may apply. So what does that mean for you as a landlord, property manager? Well, there's a couple of things. Number one, the AB 2179 requires certain disclosures to be within your non-payment of rent notices if you're demanding rent that was due during one of the 3 periods of time that I was talking about. Now, landlords, you won't have to worry about protected period debt anymore, because there's a general rule in eviction court that you only can demand rent that was became due within the last 12 months. So protected period debt is not going to be an issue anymore. But if you have any transitional period debt or this COVID recovery period debt, those notices will be affected. You will, there's certain statutory language and a disclosure that needs to be put in your notice indicating that eviction protections may apply, etc. And you have to copy that verbatim. And I think the statute says in 12 face bold point font. Don't quote me on that, but it's in the statute basically. In other words, if you don't have that language in your notice is going to be void. And for all those that have done an eviction before, if your notice is void, then your whole case, your whole unlawful detainer or eviction case is bad and can be thrown out in court, and you'll have to do it again. So that's one of the things that you'll have to face. The second issue is, for a lot of you, is if there is a pending application or the application's been approved, eviction protections have been extended, through while the time the application is pending, or the state has approved the application, but you're waiting for payment. The whole idea is the state is going to reimburse a landlord up to, I believe it's 18 months worth of rental assistance. And basically, if the state approves you for that, there would be no need to continue forward with your non-payment of rent case, basically, because the state's going to cut you a check. So that is another major feature of this legislation for most landlords and tenants. You're going to have to wait for the state to get back to you and process payment or deny your application, and then at that point you can move forward with your court case. The other third item, and it's not really a real, I'm not going to get really into the weeds about this, is if you live or you have property within a local municipality or county that regulates evictions and terminating of tenancies a lot more restrictive than state law. So any regulations passed, certain regulations passed for protection of tenants due to COVID are preempted, or the state has made the rules that govern what a landlord or property manager must do. If the local county or municipality has passed their own regulations, then those won't go into effect. I believe it would be August 1st of 2022 onward. And, your mileage may vary. And I'll put this out there for you landlords and tenants that are in a city or county that regulates evictions. Those rules are really specialized. I know we've gotten calls from folks down in Southern California about how they need to proceed and so forth. And I'm a Northern California attorney. Our office predominantly covers Solano, Contra Costa, and Napa counties up in Northern California. So my word of advice to you all there is you're going to either need to know your local regulations, or you're going to have to talk to Landlords Council down there, because quite frankly, I don't exactly know what your ordinance says or what your protections are. And if you generally, if you don't comply with your local regulations, if you have to or you're required to by law, then your case could get thrown out. So that's just my cautionary tale of advice for those that are listening. To that, know your local regulations and ordinances, what is going down there. And if you don't know, speak to counsel down there. So those are kind of the three major things that were covered under the legislation. Now, I have been getting questions. The two major questions are, Rob, do these protections apply after April 1st of 2022, or for rent that's due on or after April 1st, 2022? The answer is no. AB-2179 only regulates rent that became due during COVID, basically, or this COVID recovery period. So either the protected period, the transitional period, or the COVID recovery period as defined under state law, which is basically March 1st of 2020 through March 31st, 2022. So that it only regulates that. Anything that became due after April 1st, 2022 follows state law, basically, or if you're in a place that regulates evictions worse than state law, you got to follow your own local regs, okay? Second question I've been getting is from landlords, and it's a good question too, is what if the landlord never applied for rental assistance before March 31st, 2022? Well, it looks like what AB-2179 does is it puts a bar on that landlord from basically evicting that tenant for any rent that would be covered under COVID, basically the 2 years that we've just talked about through June 30th, 2022. And I'm getting that from Code of Civil Procedure 1179.11. The two major restrictions that were in effect for rent cases was before you could even go to court and get a summons, you would have to show the superior court that, hey, I've applied for rental assistance. Either you got denied basically from the rental assistance program or your local program that was handling rental assistance, or you had to wait 20 days and hear nothing back from the state rental assistance program or your tenant about applying. If you were able to, and you would have to just declare this in a declaration as part of your paperwork, the court would issue you a summons. But if you failed to do that, then the court would not issue you a summons. I'll go back to Code of Civil Procedure 1179.11, which also instructs courts not to enter in judgments or default judgments against tenants, where the landlord has to verify in another set of declarations saying, hey, court, I've applied for rental assistance. Here's my application, and here is my denial, or tantamount to what is a denial, because many applications I've seen don't have a formal denial, even though the legislation contemplates that you would be formally denied. A lot of times it will just be a thing in your portal, in your online portal, that just says you might get a denial, or it might just be, the application hasn't moved forward, which is basically tantamount to a denial, because how the rental assistance program works is they don't move your application until if you've applied, till a tenant has applied. So we went off track a little bit. To answer the question about landlords who did not apply, it just appears that there is a temporary bar on you seeking that rent from April 1st, 2022 through June 30th, 2022. After that period expires, it appears that the landlord at that time can bring a non-payment of rent case for those months of rent. And if you're a landlord in that situation, probably my best thinking on this, it would be, pursue your rent for April 1, 2022. Obviously, you're going to want to sit down with counsel and look at the specific facts of the case, because maybe there might be, some way to get around these restrictions. But I'm just reading the plain face of the law. It just appears that there would be a bar basically through June 30th, 2022 of bringing that case despite you not filling out an application. And to me, it kind of seems like, the state pulled a fast one, because originally when the legislation came through, it wasn't written in a way where landlords had to apply by March 30th, 2022. It just seems like the state you just drew a line in the sand saying, hey, that's when we're going to stop accepting applications. Under the old set of statutes, the statute read, and I thought as well too, that, hey, the program would continue accepting applications until all the money was exhausted. And at that point, the state would just give notice saying, hey, we're done. We ran out of money. Rental assistance is over. But that's either near here nor there. They changed the law. And again, you know, every rent case is going to have factual situations that are going to be slightly different from the other. So in that case, I'm going to highly recommend that, hey, you probably need to sit down with counsel and kind of go over your options basically at a certain point, just so you make sure you're complying with the law. You don't have a bad case in eviction court. And again, too, you might have local regulations that also impact your non-payment of rent eviction case. So folks, if you have an issue that, you know, you're dealing with non-payment of rent, again, I'm just going to throw it out there. We help out landlords in Solano, Napa, and Contra Costa counties. If you're one of those folks here, please feel free to reach out to us below here. Until next time, I know this one was a little bit longer than usual. Make it a great day. Make it an awesome day. We'll talk to you next time, and we'll see you then. Thanks.